5 seconds to go. Start. In Bhupinder Kumar versus Angrez Singh 2009 8 SCC 766, 2009 3 SCC Civil 556, this court held thus. It is clear that Section 28 gives power to the court either to extend the time for compliance with the decree or grant an order of rescission of the agreement. These powers are available to the trial court which passes the decree of specific performance. In other words, when the court passes the decree for specific performance, the contract between the parties is not extinguished. To put it clearly, the decree for specific performance is in the nature of a preliminary decree and the suit is deemed to be pending even after the decree. Subsection 1 of Section 28 makes it clear that the court does not lose its jurisdiction after the grant of decree for specific performance, nor it becomes functus officio. On the other hand, Section 28 gives power to the court to grant an order of rescission of the agreement, and it has the power to extend the time to pay the amount or perform the conditions of decree for specific performance despite the application for rescission of the agreement decree. In deciding an application under Section 28(1) of the Act, the court has to see all the attending circumstances, including the conduct of the parties. The learned counsel, appearing on behalf of the respondents, placed reliance on the decision in V.S. Palanachamy Chaitier Firm versus C. Alagappan 1999 4 SCC 702, while adverting to the decision of this court in Ramakutti Guptan versus Avara 1994 2 SCC 642. The two-judge bench held. This court observed that when the decree specifies the time for performance of the conditions of the decree on its failure to deposit the money, Section 28(1) itself gives power to the court to extend the time on such terms as the court may allow to pay the purchase money or other sum which the court has ordered him to pay. The court held, after noticing the conflict of decisions by the Bombay High Court and the Andhra Pradesh High Court, that when the court which passed the decree and the executing court is the same, application under Section 28 can be filed in the executing court. However, where a decree is transferred or execution to a transferee executing court, then certainly the transferee court is not the original court and the executing court is not the same court within the meaning of Section 28 of the Act. But when an application has been made in the court in which the original suit was filed and the execution is being proceeded with, then certainly an application under Section 28 is maintainable in the same court. In the above case, the facts before this court were that an agreement to sell had been executed 19 years earlier on 16th February 1980 and no explanation was forthcoming as to why the balance of the sale consideration was not deposited within the time granted by the court. No application for extension was made under Section 28 of the Act. This court observed that merely because a suit was filed within a period of 3 years prescribed by Article 54 of the Limitation Act 1963, that did not absolve the vendee plaintiff from demonstrating that he was ready and willing to perform the agreement and whether the non-performance was on account of obstacles placed by the vendor or otherwise. In that context, this court held the court has to see all the attendant circumstances, including if the vendee has conducted himself in a reasonable manner under the contract of sale. That being the position of law for filing the suit for specific performance, can the court, as a matter of course, allow extension of time for making payment of balance amount of consideration in terms of a decree after 5 years of passing of the decree by the trial court and 3 years of its confirmation by the appellate court. It is not the case of the respondent decree holders that on account of any fault on the part of the vendor judgment debtor, the amount could not be deposited as per the decree. That being the position, if now time is granted, that would be going beyond the period of limitation prescribed for filing of the suit for specific performance of the agreement, though this provision may not be strictly applicable. It is nevertheless an important circumstance to be considered by the court that apart no explanation whatsoever is coming from the respondent decree holders as to why they did not pay the balance amount of consideration as per the decree, except what the High Court itself thought fit to comment, which is certainly not borne out from the record. Equity demands that discretion be not exercised in favor of the respondent decree holders and no extension of time be granted to them to comply with the decree. The facts noted in the above extract from the judgment indicate a situation which is factually distinct. In that case, the balance of the sale consideration was sought to be deposited 3 years after the confirmation of the decree by the appellate court. In the present case, the balance sale consideration came to be deposited immediately after the second appeals came to be allowed by the High Court in 2018 by seeking permission of the executing court. In a given case, the trial court, while passing a conditional decree in a suit for specific performance, may say so in so many words that if the plaintiff fails to deposit the balance sale consideration within a particular period of time stipulated by the court while allowing the suit, the failure to make such deposit within the time prescribed would have the effect of dismissal of suit. In other words, there could be a decree which may say that if the plaintiff fails to deposit the balance sale consideration within the stipulated time period, the suit shall automatically stand dismissed. If such is the nature of the decree, then will the court concerned become functus officio and would have no jurisdiction to grant extension of time fixed by the decree for the purpose of deposit. This is one issue that the Supreme Court one day in an appropriate case may have to consider and decide. We say so because there are conflicting views of different high courts, including to some extent of this court. In the present case, it is not necessary for us to look into and decide this issue because the decree is not of such a nature. In the case of Mahant Ram Das versus Ganga Das, AIR 1961 SC 882, this court has taken the view that Section 148 of the Code of Civil Procedure CPC empowers the court to deal with events that might arise subsequent to an order for the purpose of enlarging time for payment, even though it had been peremptorily fixed. But in that connection, the court observed as follows: such procedural orders, though peremptory conditional decrees apart, are in essence in terrorem so that dilatory litigants might put themselves in order and avoid delay. They do not, however, completely stop a court from taking note of events and circumstances which happen within the time fixed. Stop.